women's dignity would work as a value concept?
I don't know the answer to that question. Certainly natural rights are values. They perform the role of value that Waldron does not want. I think that dignity in his account is more a filter, as your colleague was suggesting. Is the filter that allows you to narrow down the natural rights to a subset that are human rights. Okay, but again, let's try to understand why he thinks that natural rights are a good starting point for this specific third type of foundation. Now, the first thing he says is that the point I already made, that political philosophy in the last decades has consciously avoided this kind of traditional way of looking at a moral ground for human rights. Political philosophy with rules, we don't do comprehensive stuff. We don't do comprehensive doctrines. We don't care about the truth. We don't want the truth. Reasonableness is more important than the truth. Truth is divisive. Truth used to be what should unify us or what liberates us, as the gospel says. According to Rawls, truth, is divisive. So we don't want a moral foundation whatsoever. We don't want a foundation that rests on some metaphysical argument. So that's the first thing he says. And he notices that this line of thought has become even stronger recently with Charles Bates. Charles Bates produces, I think in 2009, The Idea of Human Rights, in which he says, we have to move towards the idea of being non-committal regarding the existence of this higher moral ground for human rights. We really have to say that human rights have nothing to do with this higher moral ground, which is a stronger thesis. So it's not, I can make a good enough account of human rights without referring to these moral grounds. It could be that human rights depend on this higher moral ground, but I don't need to make this reference. That's Rawls. Bates says something different. He says, no, look, it's not that there could be a moral ground for human rights. It's that there is no moral ground for human rights. Why? Because he thinks that if we look at what human rights are, we discover that it's impossible to make this connection with a higher moral ground. And now, let's see why he thinks that it's impossible. Bates says naturalistic conceptions, which would be mine or Simmons, naturalistic conceptions regard human rights as having a character and basis that can be fully comprehended without reference to their embodiment and role in any public doctrine or practice. According to such a view, the human rights of international doctrine derive their identity and authority from this more basic level of value. So, the problem with the naturalistic conception, according to Bates, is that they suggest that human rights can be understood even without reference to the specific institutional embodiment that they've had in the last 60 years. So, according to the naturalistic conceptions, we can make sense of human rights even if we abstract for a moment from the idea that there are different states. Because, if natural rights are rights that we had before the existence of the state, then human rights should be something that we understand independently of the existence of different states in the world. Or if human rights are derived from natural rights, then we should be able to understand human rights even without reference to the idea of an international community overstepping national sovereignty, or we should be able to understand human rights even without even making a reference to possible tribunal for those who commit crimes against humanity or genocide or something like that. So Bites is saying the main problem with the naturalistic conception is that they make optional the reference to institutions, to embodiment, to things like the existence of states, which are rather essential for human rights. They cannot be made optional. They are the essence of human rights. So if you conceive human rights as natural rights, you are led to believe that you can make sense of human rights even without talking about states. And that's unacceptable, because human rights were born as limitation of the power of the states, as limitation of national authority. So you're really misunderstanding, literally, human rights if you think that they are grounded in natural rights. And continues Siemens, Bites' most general complaint about such naturalistic view is that our understanding of international human rights is distorted rather than held by conceiving them on the model of natural rights. Human rights are unlike natural rights in not presupposing any one view about their basis of justification. So it's not that they are non-committal to the basis and to the deeper moral basis on which they will rest. They, according to Bites, say we do not have such a basis. And again, unlike natural rights, for some human rights we cannot conceptualize them as existing in a condition where there are no institutions, since they presuppose a certain institutional structure. Nor can we think of them as timeless as natural rights are. It's not that, according to Locke, people of the 16th century had a right to property and physical integrity, but people of the 13th century did not have a right to property. It was a timeless entitlement, whereas human rights are not timeless according to Bites, precisely because they are so strongly linked to specific institutions that are there today but were not there before and maybe will not be there in the future. And finally, where modern natural rights theories were, quote, primarily attempts to formulate constraints on the use of government's coercive power in circumstances of religious and moral diversity, the motivating concern of international human rights is evidently broader, being an effort to identify the social conditions necessary for the living of dignified human lives. So, these are the main obstacles, according to Bites, against the naturalistic conceptions, as he calls them, and in particular the idea that there could be a third type foundation that starts from natural rights and gets to human rights. They are two different. Human rights are intrinsically institutional, natural rights are anti-institutional. They exist in the state of nature. Natural rights are timeless. Human rights are not timeless. They are actually very much linked to a specific time in human history. Natural rights were meant as protection of individuals in a time of religious wars and so on and so forth. So you still have the right to your property even if you are Protestant in a Catholic country, and vice versa. You still have your right to physical integrity if you are a Catholic in a Protestant state. That was the motivation behind natural rights. Whereas human rights, according to Bates, have a much broader reach. It's not about religious wars, not only about protecting people from the atrocities of religious wars and the consequences, the injustice that and comes from religious differences, but is more in general about securing people a dignified life. Okay, so that's Bates' very recent attack against orthodoxy. Let me finish by seeing how Simon's reply. Okay, what does he say? I believe that Bates here underestimates the difficulty involved in giving, well, the first thing he does is to say, well, when you say that human rights as they are now conceived, as they are practiced today, that you can make sense of them by looking at the practice only, I think that you are a little bit too optimistic, because it's not clear exactly whether they are meant to reach one goal and that it's so easy to give them a unified account. But leaving aside this, let me confine my attention to a different problem for Bates' position, namely its dramatic underestimation of the resources available to a plausible naturalistic theory of human rights. In this case, the kind of natural rights theory of human rights that we have been considering. Bates' criticism of such a theory, remember, rest on two main points. One, two ways in which it distorts our understanding of the point of human rights claim in actual practice. So if we start from a naturalistic conception, we don't understand two essential things of the human rights practice as it is today. And number two, two conceptual bars to natural rights serving as the basis for the human rights of actual practice, since many human rights cannot be understood as either pre-institutional or timeless. But these are the two sets of problems that Bates says, and Simons will show that he underestimates the way in which the resources that the naturalistic conceptions have to reply to this kind of obstacles, to overcome this kind of obstacles. Both criticism of natural rights account in one seem to me inapt. Whether or not human rights practice presuppose one or any justificatory foundation for all human rights claims is at best unclear. Some of the important human rights conventions, as we have seen, do in fact suggest derivation of human rights from more fundamental ideas, or co-derivation of human rights along with related ideas. So, first point, are you, Bates, so sure that the very culture and practice of human rights actually suggest this derivation that you are denying? If you were right, why is it the case that all the official documents make a reference to human dignity, make a reference to something external to human rights from which human rights are derived? So, remember yesterday I talked about the inability of the political view to respect the fidelity condition. That's the same point that Simons is making here. You want to be so close to human rights as they are practiced today, as they are understood today, but let me remind you that the way in which the practice understands human rights is by making a reference to something that comes before or is above human rights themselves. So maybe you are violating the fidelity condition, not I am violating the fidelity condition. Further, Bytes' point about the breadth of the motivating concerns of international human rights compared to the narrower concerns of historical natural rights theories seem, by itself at least, a non sequitur. The fact that particular kinds of social concerns were in the minds of their author is far from conclusive in identifying the true characters of either philosophical theories or legal conventions. Natural right theory, while emerging historically amid concerns to constrain tyrannical princes and centrally concerned with identifying the moral limits on their coercive powers, can and does still have direct relevance for other kinds of social concern, such as the necessary condition for living a dignified human life. Author preoccupation do not define theoretical reach. So, even if Locke was preoccupied with protecting individuals from religious wars, that doesn't mean that the protections that he invented are not good for other kind of threats to human beings. So, in this sense, the author preoccupations do not define the theoretical reach of the instruments that they invent. So, if Locke invented a natural rights of physical integrity of the individual or natural right to property, this may turn useful also for facing contemporary challenges that no longer have to do with religious wars or stuff like that. So Locke's theory of natural rights, for instance, was developed in the shadow of deep fears about the coercive imposition of Catholic rule, but later use of very closely related views, such as those appealed to by Jefferson or some of the other American founders, drew on the theory resources to justify protest against perfectly secular political tyranny. Consider next Bytes' claims that now the timeliness and pre-institutional character of natural rights. So, natural rights are timeless and pre-institutional, human rights are time-bound and institutional in nature. Okay, well, the main point he makes against this charge is that there are two ways of taking the champions of the natural right theories that he considered Locke and Kant. It could be discussed whether Kant is a natural right theorist, but let's concede this to my friend and colleague Simons. But anyway, he says, okay, let's take the two champions of the natural rights law, John Locke and Immanuel Kant. Are we sure that their theories are so distant from the time-bound nature and the institutional nature that human rights have today? And Simons concludes his argument, his paper, by showing that no matter whether you start from Kant or from Locke, you still have the resources to account for this time-bound nature and institutional nature of human rights. So, let's see. The Kantian tradition is committed to only one innate natural rights. As you might know, in the Metaphysics of Morals, Kant says there is only one innate right, if you want, there is only one natural right, and this is freedom from external interference by other people. So external freedom. There is an innate right, according to Kant, to enjoy a sphere of action, if you want, of external freedom that is limited only by the fact that your sphere of freedom cannot be bigger than the sphere of freedom of someone else. It's pretty much the same idea of the first principle of justice. So the state or any other individual has no right to make your